I'm going to nominally assume the role here of moderator, although in reality, Omar and I are going to cooperate on this. He set such a high standard on keeping things moving in that first session. I know I can't meet that, but maybe I can approach it if I can have him backstop me a little bit on this session. So I think our plan is to go until about 12:45. So, you know, in there, a lot of what I think we'll end up doing is following through on some of the issues that were raised already, or the implications of some of the points that have come up. And of course, we talked a lot about the international tribunals, ICC, and the ad hoc tribunals. We talked about the role of domestic courts, and especially as the principle of complementarity is brought into play with regard to the ICC. Charles, you're quite familiar with the regional possibilities, and you've worked a lot with the African Union, and you've thought about the possible role of regional institutions in. I mean, I think Beth at some point said we might have, you know, like a 4-level thing. Well, the truth is, it's all in flux at this point, because even at any given level, the parts that are more or less corresponding are different and may overlap, or in jurisdiction maybe gaps. But you've thought about the regional possibilities, and if you could flesh out some of that for us at this point to start this next session, that would really be terrific.
Oh, great, thank you so much. You know, in fact, it's my thinking on this is probably in terms of the academic side of it. I'm doing more recently along with Linda and Mark, because that's part of what we're looking at for this book that we've been working on. And my task was to sort of begin a first take on it for us. And it was interesting for me to look at the present state of the discussion about international criminal law, especially if you look at the ICC and the sort of African government pushback at the ICC and some of the criticisms there. And what comes out in the end is sort of a deep level of suspicion as to sort of regional components and whether they have a place in an international system. And what I thought was interesting once I started doing research on the question was, it turns out that we've been there before. When you look at international human rights law, it turns out that around the founding of the UN and the adoption of the Charter, when there had been discussions already about the place of international human rights in the state-driven system that we heard so much about from Stephen earlier. And then there's this notion that, no, we're not going to do too much on human rights now. Let's kind of codify once we get a standing body. So we'll make some references in the preamble to the fundamental freedoms and how important they are and all of that good stuff, throw in Article 55, and then sort of like leave it and then come back to the question later on. Well, it turns out when we went back to the question about how to deal with human rights, in particular at the universal level, there seemed to be a preference for an international system in the early days and a deep suspicion about regional options. And the idea was, I guess, it's sort of seen as a break from universalization to accept regional options. Yet, of course, we know the way that played out, because now we can look back with the benefit of hindsight and see that it ended up being that international system, we could agree on substantive norms, but very limited enforcement mechanisms. So it was because, of course, the big Cold War context, you know, the East-West divide, even the notion of whether the right side we should worry about, the whole famous divide. Once we got past the Declaration, they're having a civil political rights covenant on the one part, and then the economic, social, and cultural rights, and those disagreements. So in a sense, we morphed into accepting regional options and having courts within regional systems that were driven by sometimes very separate imperatives at the regional level. Think about Europe trying to kind of get back on its feet and seeing human rights as a way, human rights protectors, to kind of push back on totalitarianism and so on. So we saw this inevitability, in a sense, in the international system, where now we have this system of international human rights enforcement that's both international on the one part, but also regional, and some might argue more effective at the regional level. So I wondered, and we've been wondering in a way, whether international criminal law could look at that experience and see, because in a way, there are some parallels. We took a long time to get to a permanent tribunal. We talked about it in 1948 with the Genocide Convention, so it eventually happened in 1998. But we've gotten there. Yet, complementarity, I think, is a big winner, that I think there was not going to be. I mean, I know the civil society actors that pushed back. They wanted primacy as an organizing principle, but that couldn't work at an international level. So I think it was the right option to choose. But what we're seeing now in the practice of the ICC is that there was a fundamental assumption that we made at Rome that is no longer true, at least by the practice, whereby we say national jurisdictions will step up and be the first to prosecute, right? If they fail to do so, we have the criteria, then it kicks to the international system. But how many of the countries are running to the ICC? Basically, wanted to give it up. It's like they're not guarding their sovereignty anymore, they're doing the self-referrals, Uganda, all the historically cases that you know of, to the point that it's almost like the ICC is becoming a court of first resort as opposed to a court of last resort. So raising questions again then, if complementarity is not going to work because countries are not stepping up or they're claiming they don't have the ability, because I think there's a lot of the active question, countries don't have the ability. If you think about the admissibility debates about Kenya, for example, obviously there's a political side of it and some for the political manipulation. But if Kenya would not qualify for admissibility, I would not imagine many African countries would. In terms of a country that has a good legal system generally, now I know the politics is part of it. I know that there are options that were discussed at the domestic level in terms of domestic prosecutions, both within the domestic courts or even a special tribunal for Kenya, the famous SDK that never saw the light of day. So raising a question, and if we're thinking about it at big picture, systemic level, for me, it seems as if this 4-level, or at least 4 levels, because it could well be more if you add the sub-regional dimension, right? So then it becomes 5 levels of enforcement of international criminal law might not offer us something going forward if we're looking for that accountability, which the French may not understand, but the rest of us do, right? The Pocar is giving us a nightmare. It's a really lovely one, right? I guess I express it differently. So in a sense, if you think of the African example in that broader historical pattern, it seems to me that we shouldn't dismiss it. We should engage with the possibility, look at what's happening in other regions, and if you think about the Inter-American system, they've definitely gone very far to the point that scholars are now describing a quasi-criminal jurisdiction, essentially created in between the commission and the court, basically ruling in favor of the right of victims to remedies, including prosecutions of the violators of human rights, torture, disappearances, and so on, and basically making it up judicially as they went along, and sometimes getting a little bit of pushback, where they're encouraging prosecutions, to the point that scholars are saying we're seeing direct prosecutions of what will be issues of international concern like torture as a result of rulings of the Inter-American Commission. Could it be that we might take the next step? Could it be that we might see in that region the possibility of now codifying within that system some kind of criminal jurisdiction in the way the African system is proposing? Now, there are going to be a lot of issues, I think, with that. It's not to say there's going to be a magic bullet, but I don't see us achieving some of the big picture goals that we have, especially if complementarity at the national level. I mean, you have 34 countries, and you have a handful that would qualify to be able to do good prosecutions that meet the fair trial requirements that Mark is insisting on earlier.
Well, touching that point first, the capacity of nation states to undertake domestic war crimes trials in a post-conflict environment is really difficult. There's no question about it. I think you have to, that has to be your bottom line on that. But it's not impossible. And or I should say it is impossible unless the international community takes a very active role in providing assistance on that. And that's where I think the international community does not have the capacity or the willingness to do that. That's where a sea change has to happen. There's no mechanism to do that. The last time we saw it was in Iraq. That was an American-driven technical assistance project to the Iraqi High Tribunal. From a state, from a country that invaded, that credibility was going to be questioned from the very start. That's a problem. You need an objective mandate from the international community to engage with nation states to provide that assistance. The other point, and I agree with Charles, self-referral to the ICC was never contemplated in the early days. It was not even thought about. Who was going to use that? Yeah. And so I agree with him that it's quite striking that you have the majority of the cases that are in front of the ICC coming from self-referral. But I still think if you put that aside, I still think that's an exception to the rule. I think state sovereignty is so strong that states are going to be very reluctant to give up this degree of sovereignty to this international court because it would much rather try to undertake those trials. And Kenya is an example, Bangladesh is an example, the most recent one, of course, Iraq, as I mentioned, Libya. I think that's the model that you're going to see. And whether or not we have the ability to support that type of judicial process on the national level is what is really a challenge.
Can I very quickly on the point?
Yes, and then I think Beth also has really thought a lot about the hybrid possibilities, which would be one form we've seen in terms of Sierra Leone and Cambodia. So maybe we'll go to that and then Fausto.
Well, okay, just very briefly on the element about the national. I mean, I think I would agree completely that in the end, I mean, even the statistics that you gave us, Mark, like earlier, I mean, number of conflicts, number of victims, and number of prosecutions, right? It's like, it tells the story. So the question becomes, because of the context that we're dealing with, and I think the ICC has a very difficult job of being in ongoing, active, live, constantly changing situations. So they're dealing with, it's kind of not grappling with it, the conflict has ended. The conflict is ongoing right now. And so much changes on the ground. So if you think about the fiasco that Sudan and Darfur for the ICC, right, in terms of this, being dragged in there by a Security Council referral, they're like left to hung to dry basically by the council.
By the way, does do nothing to support.
Yeah,
they do nothing to support
right.
the court for a referral, in essence, asking the court do the job that the international community has failed to do.
Right.
We're going to give the court that responsibility. By the way, we're not going to enforce it. We're not going to give you any extra money to do it. It's a disaster.
So, and that's part of the problem, right? Because that's it. That's why I'm thinking that we ought to be creative in terms of, yes, it's got to be at the national level. And if you think about the design, I don't want to caricature the African protocol that they're proposing. There's actually a complementarity there too. Is that the African states parties will have the first responsibility to prosecute, and failing that, and there they have a double failure kind of thing where if regional, sub-regional, so the ECOWAS Court of Justice, for example, or the East African Court of Justice, where they've discussed this actually concretely in the context of a Kenyan proposal, to add criminal jurisdiction there, then if, like, I don't know, Kenya can't do it, it goes to Arusha on behalf of East Africa, and if it doesn't work there, then it points to, well, I guess Arusha again, in a different way, right? Because a different Arusha court down the street, that would be the African court, or then failing that potentially go to the Hague. So my feeling is, Mark, in a way, by way of response, the lack of capacity is a critical component of the problem, and the unwillingness, rather, of the international community to provide the resources. If you think about even the ad hoc tribunal model that we have, when we think about what Beth is going to have to tell us about hybrid justice, one of the criticisms that we all know of is that this was an effort that was laudable, the country wanted to prosecute, but they were told, only if you can get donations for this court, and only if you don't prosecute more than a handful. Now the criticism of that is that, of course, we like the accountability we got, but as Bill Shepard says, we haven't had much justice in Sierra Leone because 32,000 perpetrators, according to David Crane, we have about 10 guys prosecuted. Sierra Leone hasn't touched anybody. And it said to the international community, we don't have the means to do it. Help us. And it was told, this is what you're going to get. So you take it or leave it. So my point is that there is some kind of negotiation that we have to, between the ambitions we state and then the follow-through that we give at the international level to get the accountability. And in my mind, if we can encourage states to come together, even if it's a sub-regional level, because of sovereignty concerns, to do it at the sub-regional level credibly, in line with international standards, then that's fine with me.
If you were going to respond, so why don't you say what you're going to say for a bit?
So you described my paper as magisterial, which is just a nice way of saying it's really long. So a lot of what I did in government was either supporting, conceptualizing, building proposals, or tweaking proposals, critiquing proposals, etc., for hybrid institutions. This idea of the domestic system can't do it itself, the international court can't do it alone, and we need to think about middle ground. And I think this is indicative of a decision Ron and I made on our case book a couple of years ago, when we used to have a separate chapter on hybrid courts. And a couple of years ago, we took it out because we thought, well, everyone says the ICC is here, that will be the only game in town, all the cases will funnel there, or they'll be handled at the domestic level. We'll have this sort of complementarity regime. And now we're realizing the error of our ways, and we have to go sort of dredge that up and put it in the next volume, because it's all about hybrid courts now. And that's really being seen, I think, as a solution to this dilemma. The ICC, it is there with all of its flaws. It's doing some good work, but it's certainly hamstrung, I think. The domestic courts can't do it all, but they can do some, and maybe we need this middle ground. And so what I try to do in the paper is survey the field from, and not all hybrid courts per se, but basically all the types of internationalized entities that we have as an international community created, supported, funded, and are oftentimes criticized. And what are the various dimensions of hybridity? Where can you add international assistance in terms of subject matter, the substantive law, the procedural law, staffing, personnel, how it's created. Is it created through an international instrument such as a treaty, or is it created by domestic legislation with technical assistance from the international community? And surveying the scene along all those different versions of hybridity and thinking about what we've learned about what works and what doesn't work. How do we fund these exercises? How do we not fund these exercises? And there are some really interesting models out there that I don't think get as much attention. So you mentioned the Serbian War Crimes Chamber, which is interesting. Bosnia had a similar one. Basically, almost entirely domestic, except insofar as there were international norms that were being adjudicated. But there were international personnel sort of sprinkled throughout on the registry, on the prosecutor side, in the chambers, often in the defense side as well, just to sort of raise the game a little bit of those institutions. In Guatemala, we have an entity called CICIG, which is not supporting the courts, but it's essentially supporting the prosecutor's office. Again, surging international expertise there with UN funding and support on the idea that it will do better if it has a little bit of backstop. It's the international community. It's there for legitimacy purposes, it's there for technical training, it's there for providing sort of a bad guy that you can point to if it's hard for a decision to be made by a domestic actor, and then you've got some international support as well. So I think it's a really fruitful area. There's a number of very sort of cutting-edge efforts in South Sudan now, Central African Republic. The Extraordinary African Chambers, who are trying Hisan Habre, I think is a really interesting model. And one of the questions I raise but don't really answer is, how much international is enough to call it an international tribunal? And these hybrid institutions have been able to avoid some of the obstacles or barriers that might exist in a domestic prosecution. So no statute of limitations. So if there's a domestic statute of limitations, it would apply if you were prosecuting someone domestically. It is governing on a hybrid or supranational institution. Nullum crimen sine lege problems, right? If domestic extant law didn't make the actions criminal at the time the individual acted, there may be constitutional impediments for that case going forward. International, quasi-international tribunals are not bound by that. Domestic amnesty laws, they're not bound by that. We have, Special Court for Sierra Leone and ECCC, the Cambodia Court, both have rulings that said it's fine if the domestic system wants to implement amnesty. That's a human rights question, maybe to be challenged by a human rights court. We don't have to respect that amnesty. It leaves the question, though, of how much international is enough to get away with some of these moves. And I think the EAC is maybe on the very edge of that, right? Where there's, I don't know how many internationals there are. Very few. They're all African Union individuals. And yet they've gotten around a nullum crimen argument that stymied prosecutions in Senegal and actually went to one of these sub-regional courts that said, you know what, you're right, Senegal, you cannot constitutionally, legally prosecute him because you're prosecuting him under crimes that didn't exist in your code at the time he's accused of having acted. And so it's a minimal internationalism, but it's just enough that we've all been willing to accept that they're able to do what you say, which is rely on what extant customary international law was at the time. Customary international law comes to the rescue again here and enables accountability to move forward.
Oh, sorry, Leigh. Go ahead. I just wanted to jump in because of something I was thinking about with the Bosnian War Crimes Chamber. And one thing that Beth just raised, I was in Sarajevo in May, and I was meeting with people at the Bosnian War Crimes Chamber, and they have switched from having had international staff to phasing them out so that it's all national now, which sounds like a really good thing. And I thought they would say they were glad to be rid of the international staff. And to a person, the judges, the staff, were saying they wished that that had not happened so quickly. And the reason wasn't capacity. They had gained the capacity they needed. The reason was the credibility of the court in a very divided population. And you used the word legitimacy. And so I think that's something I'd be interested in everybody's thoughts about that, because I think at a national level, regional level, international level, the credibility or legitimacy is a huge issue. And we may be overlooking how important the international players are in these hybrid courts, thinking it's better to make it all domestic, when maybe, at least with Bosnia, they would have preferred to have had them stay longer.
Okay, Fausto is.
Well, there were 2 points I wanted to make, but now I take the one of the hybrid, mixed, whatever courts. I don't like the word internationalized, by the way, because I believe these courts have to remain domestic. So I prefer calling them courts with international participation, but that's a different issue. But they remain domestic because this is essential for the principle of complementarity. And already, I think 10 years ago, I wrote saying I favor these courts because justice occurs close to the place, close to the victims, is better perceived. It's a domestic court is better accepted. Normally, the case of Bosnia might be different. You need some correction, international correction, but certainly justice is better accepted if it's done on the place and not at the Hague. It's or elsewhere. But it's important that they remain domestic. The issue is the law they apply. So the essential problem is what is the law applicable by these courts. And this is international law. Must be international law, essentially, not domestic law. Or a mixture of domestic and international law. Because that too is one of the features of this court. They apply both. If the rule exists in domestic law, you can remain with that. And if you look at the complementarity system of the ICC, it is flexible on the characterization of the crime. While the ICTY and ICTR are not flexible. They say if you convict for the killing as a domestic crime, the ad hoc court will have jurisdiction, simply. The ICC doesn't say that. It can be brought under the unwillingness principle, but it's very, very, very limited. I don't see the court taking a case which has been adjudicated as an extermination domestically, saying, no, we have to try it again at the Hague. It will be unacceptable only because it was a domestic crime. Because after all, the problem of the impunity has been resolved in a way. Whether it's been resolved under international law, domestic law may not count. But it is important that in case international law applies, this is the only directive. The other point I wanted to make in favor of what Mark said in a way is that to push the states to exercise jurisdiction, first assistance needed, that's clear in many situations. But it's not a question of recognizing essentially the responsibility of the state. The crime is committed by an individual. It's committed on the territory of the state. There is, in parallel to the individual responsibility, the responsibility of the state. If one looks at the system of human rights, which remains the basic system, it goes to the responsibility of the state. It neglects the responsibility of the individual, although human rights bodies always told the delegations coming before them that for heinous crimes they have to exercise jurisdiction. Also criminal jurisdiction as a measure of protecting the rights. So if one combines the two, it could be, the state that does not exercise jurisdiction would be not only just unwilling and and lead to the jurisdiction of the court, who is responsible for not doing it? And if you look at the Geneva Conventions, they're already responsible for that, for the great breaches. There is a clear responsibility of the state in the convention. Nobody looked at that. But in fact, the system is already based on such a principle. Right? So when it was not clear whether individual responsibility could be international, the Geneva Convention decided to leave it at the domestic level. In a way, it's part of the tension that was discussed at the beginning of this roundtable.
Well, yeah, Leigh,
I
yep.
just wanted to make a brief comment about the extraordinary African chambers. I'm glad you brought it up. It's a court I've been following because I lived in Senegal for many, many years. And so again, for those who don't know it, it's a Senegalese, it's a court within the courts of Senegal that is trying a Chadian dictator who was living sort of under house arrest, not really though, in Dakar for years. But it's interesting because from the face of it, I mean, you have this court there, there are no Chadian judges, they don't speak Chadian languages, they're all Senegalese, I think there's a Burkinabe. So what's the difference with it being at the ICC, if you look at it just on the face of it? But you have to look at the symbolism. And this criminal justice doesn't take place on a tabula rasa. There's a whole historical context that's extremely important for the legitimacy of some of these institutions. So I think it's interesting to just see, you know, how are the Chadians sort of perceiving this justice because it's taking place in Africa.
No, John, just listening to, I mean, there may be coming a consensus on this on the hybrid part, because I too have written a most recent book about really in the post-conflict environment, as I said earlier, extremely difficult, if not impossible, for a domestic process on this. But the legitimacy issue that Linda brings up is absolutely key, that with international participation, you can really reach that. Beth asked, well, you know, how international should international be? For me, it's providing, assuming there's willingness to the judges, prosecutor, and the defense, because that's oftentimes missed. And there even may be a different element to this. On the Iraqi tribunal, the Iraqi High Tribunal statute had there the opportunity for the court to engage international experts, actually engage them in a very structured way. And just as an insight, what the IBA did at that time was to create a small group of experts. Richard Goldstone was one of them. There were several others, because the judges had approached me and said, we would like to have not somebody sitting on the chamber. We want this to be domestic. That was important, as the judge says. But listen, there are issues here that we're going to be wrestling with. Could you create an amicus type group where we can fire some questions to you? And I did that, and 8 of those requests came in from the judges during the Saddam Hussein trial on really substantive important issues. You could sense what the judges were wrestling with by just them asking, what's the international law issue on this particular, impunity was one of them, for instance. And we did that. We provided them with that type of analysis. Now, what they did with it was up to them on that. But that's one approach that even, it wouldn't have to go as far as assigning people there. And we actually had a judge, a UK judge on the ground helping us on that. But the last point I want to make, in the sense of the practical part, with the fall of Gaddafi, I was in Baghdad. I get confused to hell where I am. In Tripoli. It was Baghdad the week before. In Tripoli, and I had meetings with the Minister of Justice at that time, and I knew this trial was coming up. They had made it quite clear that they were not going to transfer Gaddafi or any of the individuals, al-Sanusi. They made it, he was quite adamant, and this was during the ICC admissibility hearings. He didn't care. It wasn't a question about this. It wasn't going to happen. So So I said, well, would you accept international assistance? Would you accept somebody coming in and helping with this court that you're going to create? And he said yes. But that's where things falter. Let's put aside the security issues, because immediately after the fall of Gaddafi, things were fairly stable. But there's not an international mechanism to do that. The ICC doesn't play that role, and there's nothing out there to immediately respond to a request of a domestic jurisdiction from the Minister of Justice who's saying, yes, I'll accept that assistance. There's just not, it wasn't out there. The IBA, we couldn't do it on our own. So that was my point of saying, looking ahead, what can we do to provide that support? But I like this, you know, the hybrid nature or the domestic court with international assistance is absolutely key, I think, on this.
Well, just sort of following on that, I wonder about the circumstances in which it becomes useful to regimes to have the political cover that a measure of international participation can afford. And I mean, it would be interesting to try to map out the circumstances in which it happens, and I suspect that we would also see that it might play out differently with respect to different categories of crimes. And so, really 2 points, and they're more maybe in the nature of questions than anything else. Number one, what is striking to me is I think that there has already been a fair degree of post-conflict, and immediate post-conflict and during conflict prosecution within national jurisdictions for terrorism-related offenses. And in the Middle East, you see a lot of this happening. It's an arena where there has been a distant degree of international supervision, for example, by the Security Council, but also varying degrees of international capacity building. I mean, the CIA, for example, has been enormously involved in that arena, which both elevates and diminishes the legitimacy of the prosecutions that have been undertaken. And so the question may be, to the extent that anyone wants to take it up, is the extent to which, as we're thinking about national prosecutions, terrorism-related offenses present a different kind of case, a different kind of approach. And then the other thing that I just wanted to maybe put on the table, I was sort of thinking about the fate of the various Arab leaders who have been ousted over the last few years, and those of whom, and particularly the fate of those of whom who were subject to national justice. I'm not sure prosecution is the right word for either Saddam or Gaddafi. But I wonder I guess at the end of the day, what the implications are of that recent experience. Are they an indictment of sort of national justice efforts at the end of the day? Like, do they point us back to the realm of the international? Or if hindsight is 20/20, can we see in those instances, and even with respect, for example, to the trial of someone like Mubarak, whose trial is laughable in a range of ways, but on the other side of the coin, are they arguments for a higher degree of international participation in national justice? Arguments for an international criminal justice system. Longer than 10.
Can I chime in?
Yes, sir.
Okay, just a couple of quick points. I mean, the point about legitimacy, and I'll come to Omar with some of my own skepticism in the sense that comes out of the second question. So on the legitimacy point, it's really interesting that typically, at least in the domestic criminal justice systems, we take for granted that it's better to try a person in the community where they committed the crimes. I mean, the US criminal law, as Canadian, any British or Anglo-Saxon based system, change of venue is a big deal. in our logic, in our jurisprudence, and so on. And you say this in Nigerian courts, in India, right? So it's like in a sense a global phenomenon, like an attitude that ties into the kind of justice that we're trying to bring where the victims are and so on. So of course international criminal law, of course, is a different kind of problem because now we see the promise tends to be more international, even though, as Mark was saying, it really in the end is about domestic criminal prosecution. So my question is, could we not, in some ways, be doing a disservice if we don't take up these sub-regional options, these options that Leigh, you mentioned, the hybrid chamber? I mean, I see that as an incredibly positive development if you think about where we are with the debate about international criminal justice. And you are right, it makes a difference who the people see in the courtroom. Who is in the prosecution side? Who is in the defense side? Who is at the judicial side? Who are the court officers there? I'm not saying I'm arguing for an entirely international, domestic process when sometimes we want international to even just break deadlocks domestically, right? So politically it might be good political cover for us to say, hey, don't blame me, go to the UN, we'll complain to Annan or Ban Ki-moon if you have a problem with what we're doing here. Because this is not our court. That's what Sierra Leone basically said. When the government of Sierra Leone was put under the spotlight for not doing enough prosecutions, they said, no, we as the international community will help. Now we have the special court. This is what they gave us. if you have a problem, go to New York. Now, obviously, they were not being forthright. I mean, there are lots of things that they could have done at domestic level. And they even indicted 55 individuals for war-related crimes in the so-called West Side Boys trial in the domestic courts. And interestingly, what occurred there undermined the government's own claim to the international community, which was to say, we don't have courts that will give fair trial. They acquitted over 45 of the 55. The local court said, government didn't prove its case, sorry. Incredible stuff, right? In terms of the independence of the judiciary and some of these arguments. So I'm just saying the political cover that was given there by the international option tied into perhaps an unwillingness to revisit a difficult question that tied into the amnesty and how controversial it was in Sierra Leone. We're bringing it back to the hybrid chamber. What is significant is that the justice is happening in the region. The arguments that someone could now make from Jamena against the hybrid chamber will be different than the argument that they will make vis-a-vis the ICC of white man's justice. You're right. This is happening in a historical context where one part of the world was basically subjugated. Let's not forget that. For a long, long period of time. So it will be quite an affront for a lot of people, at least at the historical, symbolical level, to say, okay, well, now these are the people bringing us justice. In Namibia, people still talk about the Herero genocide. Is there justice for that? People are talking about slavery. I don't know whether international law provides answers today as it's conceptualized, but don't forget the critique is that's a system that was taken over by the powerful so that they could impose these laws on the rest of us. So in a sense, it has tremendous political resonance, even if it's not based in a strong reality in terms of where the world is today. But I actually think it would be too simplistic to say this is a Western kind of system now. African states are buying in, they were Rome negotiating, pushing for a strong court, apparently on their own argument because of what happened in Rwanda. They wanted to have a court that would deal with that kind of problem because they felt that the international community abandoned Africa in its biggest hour of need. So they wanted to put a stop to that. Now, obviously, a few years later, they've sort of changed their minds. But just to say legitimacy is critical, it has to be domestic. Quickly, political cover. I think that international can be used both in good ways and bad ways. And we cannot forget that. So when we talk about domestic prosecutions being the ultimate solution with international assistance being the added layer, we have to be careful in how we go into different contexts because in some cases, that manipulation could go the other way. And I'm not too happy with some of the outcomes of some of these trials. And unfortunately, Saddam is one of them in my own mind because we all were very concerned about the fairness of the process. This is what it is about in the end, right? So we saw the process and defense counsel were killed in the process, judges were resigning. I mean, it was almost like a charade, right? So to what extent did the justice that was given there helpful for that country moving on from just this very difficult, 40, 50-year period of its life, basically, right? How does that play into the global power politics of who decides when that justice is given? We cannot forget the role of the Security Council. The Security Council says we're justified in the maintenance of international peace and security to override sovereignty, essentially, and impose a tribunal on the state, but has its double standards. If we talked about Syria. Nobody's talking about justice for Syria in the council because we know why. So in the end, I'm saying I agree with that there's an issue there. Political cover, international involvement has a double-edged sword to it. It could be valuable, it could be problematic, and we have to calibrate for each situation.
Is there anybody else who wanted to respond to Omar's comment? Otherwise, I maybe raise another issue. And this really, Charles, ties back to something you said a few minutes ago, that in Sierra Leone, the international community was willing to fund a hybrid, but only a tiny hybrid, and they didn't want it to be too ambitious, and they were worried about what it was going to cost. And I guess I'm curious, and I'm going to start with you, Fausto, because you, as president of the ICTY, had to figure out how to pay the bills, how to keep the heat on and get the computers and the translators paid for. And you may have some views on the evolution. Of course, now as the ICTY winds down, it drags. It's hard to make sure exactly when it's going to end and whether it's being wrapped up the way one would have hoped it would be. And of course, all these other mechanisms have been talked about. It's all done on sort of an ad hoc basis of money for this, money for that. We'll do it if you can come up with the money. So my question is, is there any reason to think that the international community is really willing to pay for international criminal justice? To pay what it would take to do it the way the people on the panel are describing it should be done. And if so, how could it be done? Does there need to be some independent funding mechanism that countries can put into that then can be used, at different spigots, some hybrid and the ICT is obviously on its own path with its own challenges about trying to come up with money, and so let's maybe put that off on the side. But you had to go hand in hand to the UN and ask for money to keep your operation going, right?
Yes, but you are putting the question in resources.
Yes, I'm really quick.
But,
will there be resources, and where will they come from?
I don't think this is the problem. Actually, it was never the problem. Although it was always said in the UN that this justice would cost much, was a cost that international community cannot support, and so on. I think it was just a pretext, in my view. If one looks at the budgets and looks at how much a day of war in a country costs, the budget of 1 year may be a week or even less of war. So it's really nothing. The problem is political. How much you want to invest the money for justice, and not in other activities. There may be even social activities, economic development. That's always a problem. But I think the problem is essentially political. And here we have a political problem, I think, in the current system. You were mentioning the downsizing and the closing of the ICTY, ICTR. Now, it may be shocking for those who are not implicated actively in the work that the ICTY closed in 2013. The 1st of July 2013, the ICTY was declared closed, and this is going on. But it was closed. And the ICTR was closed in 2012. Now, and went on until the end of 2015 in practice. What was done, and that was a political decision, was the Security Council created a new body, which is called the Residual Mechanism for the two tribunals. One only, that started working in 2012 as the ICTR, and included also the ICTY the following year. But this was for residual activities. The initial idea of this was to have something that when you close, you cannot close completely. For instance, you have to protect the witnesses. There are judicial decisions that may be valid. They can go for years. You have to supervise the certain sentences, can go on for years after. So you can't close completely the tribunal. And that was my idea. It wasn't one the initiator of that idea, but as a residual for residual. You have a review case after 10 years because evidence appears that a convicted person was innocent. You have to find a mechanism to resolve this problem. And various other issues of this kind. Now, what they did in parallel, the tribunal continues to finish the cases that are pending in the stage in which they are. So if a appeal goes to the end, if a trial goes to the end of the trial, the rest goes to the mechanism. So that means the residual mechanism will have, and has already done something as to Rwanda, to follow up and deal with the appeals. But what is the wrong in all this situation? First, it costs more. There are two budgets, and for 4 years, there were two budgets. Claiming that it costs less, it's like having a car that doesn't work well, but you keep it for 5 years, and you buy another car at the same time and use both. So it clearly costs more. So that's quite clear, seems to me. So it's not a question of finance problem. The problem is political. And the political decision was to reduce the judicial guarantees. Because the mechanism is based on a principle that is not the same of the tribunal. It's a roster of judges and one permanent person, the president, who has the responsibility of calling in the people when they are needed, as he wishes. But it's easy to understand that the shortcomings of the system of this kind, because, especially because in parallel, because some of these 25 judges in the roster are also judges of the ICTR at the same time, of the ICTY at the same time, and the ICTR before. So they could be chosen for activities that already occurred, were carried out by the residual mechanism in parallel, according to how they behaved. You had the same person presiding in two. So he, on the one hand, has to deal with the cases in the ICTY, on the other hand, to deal with it. Can a person resist really to making an evaluation of the behavior in one body for choosing the person in the other body? Perhaps yes, but I'm not speculating on the person doing not well. But the system that allows for it is the wrong system. If judges can be selected on how they behave, majority can be decided at the moment of appointing the judges. So this is a question, and it might be the case. Of course, I don't say it will happen, but it's certainly something that sets aside part of the system. And in New York, there are people in the legal counsel office that say this is the new model for international justice because it costs less. Because the judges in the roster are not paid, are paid only when they work, and their salary is decided by the appointing judge. Because there's a system of the ad hoc judges of the LCJ, where they are not paid the full salary, and what they are paid is decided by the presiding judges. So, I mean, you can choose the people, you can say how much time they serve, because an assessment how long the case will take is made by the president decides how much they are paid. Is that a system of justice? I have serious doubts. That I don't say it will be abused, but the system that can be easily abused is a rocky system, clearly. So are the states really, that's why I say it's political, are the states really committed to do something. And if you look at the ICC, the ICC, the Assembly of States Parties, that wants to control everything, not leaving any space to the court. Is that acting for the independence of the court, or they want to control it? And are they in favor of justice or not? So there is a political problem that has to be.
And every single one, like all the examples that
I just
Beth
made
was
some
listing
examples.
of every single possibility of international involvement, you've got the question like, well, do we really want to invest in that? Well, maybe we would invest if they'll do what we want them to do, or we won't invest if they want to go off on their own. And as Charles is describing kind of from the other side, that will we be willing to accept support potentially, but only to do things that we think are worth doing. To have somebody pay us to do something that we don't think is worthwhile or we think is illegitimate, that isn't a very good path to be on, but it can be tempting, I'm sure. I don't know if anybody else has any.
Can I make a
thoughts?
comment? I was, in preparing for this conference, I was rereading one of our past reports of Brandeis Institute for International Judges, and both Fausto and Leah were there, and the session was on the future of international legal institutions, not specifically criminal, but one judge did say, and this gets back to your point, that one F-35 stealth fighter costs twice as much as operating the ICC for 1 year. So it's a matter of choice of where resources are going. But another judge had a very novel proposal, which is that the Assembly of States Parties should call on transnational corporations to put in money into the budget because their bottom line is affected by mass atrocity crimes where they do business.
Speaking about funding, I think it's definitely a political issue. There's also a legal impediment, I think, which, if people are looking for no topics, it would be something that would be really, maybe not the sexiest topic in international criminal justice, but it's really an essential topic in international criminal justice. So the ICTY and the ICTR were funded from UN-assessed contributions, which meant that the US paid upwards of 30% because 30% of the budget often comes from the United States. And so that has its own issues, but at least there was a ready pot of money. And the MICT, this mechanism, will also be paid out of UN-assessed contributions. Why? Because it's a Security Council entity. So when they created the Special Court for Sierra Leone and the Extraordinary Chambers of the Courts of Cambodia and even the Special Tribunal for Lebanon, they didn't use the mechanism of the Security Council resolution. And as a result, UN-assessed fundings are not available. So those tribunals were left to engage in to seek voluntary contributions, and it was a constant struggle. I mean, you probably did a lot of panhandling, forget it. These poor staff and principals were every day. I mean, the ECCC literally got to the point a couple of times where they could not sign employment contracts legally with staff because they didn't have money in the budget to pay them. They knew it was coming and so-and-so had pledged this much, and David Sheffer, the former ambassador at large, was out there like gathering pledges, and little Argentina gave $30,000 and was like, I'll take it, whatever he can give. He writes a check every year, so he feels like he can go out and raise money for this entity because he's asking others he's also put in. So that's an issue, and part of the problem is there is an ICJ case, and there's some corporate law principles that suggest that the UN should not be funding entities that are not subsidiary entities over which they have accountability. And so that has harmed the ICC case as well, because that's one of the arguments that gets made for why the General Assembly shouldn't be empowered to issue appropriations for Security Council referred matters. Even though the ICC is essentially doing the bidding of the Security Council, they can't get the funding. And there's some concern about floodgates here, where every African Union peacekeeping exercise or some other entity says, but we're doing the work of the UN, so we need UN funding in which to do it. So they're trying to cabin that. Now what's interesting is there have been some kind of ways around it. So
Can I ask you one question on the funding part, because you were inside the government. The sense is it was the United States that really drove this issue of we are not going to permit the Security Council in referral. We're not going to permit money to be attached to that. Is that true?
It is true insofar as in the decision-making in the Council, I think that was definitely a U.S. position, and they're on record of that. In part because we have our own idiosyncratic statute. There's actually two statutes that prevent the United States from easily funding activities of the courts. One statute is a complete bar, and it would have to be amended or repealed in order to get around it. The other statute, there are ways around it, the American Service Members Protection Act. They've never been explored because this other statute is still in the books. That said, there are lots of other non-state parties within the UN that wouldn't want UN-assessed funding to go to the court, even if it's a Security Council referral. Some of that is due to sort of hostility toward the Security Council. Some of it is due to more principled arguments about sort of control and what UN funding should go toward, and we should be funding activities of the UN and not activities of outside entities. So it's certainly a position that was supported by the US, but it's not a position that's exclusive to the US.
Got a hand or?
Just very quickly on the point.
Okay, and then I think what we could go on for hours. You're afraid we will, but we can open up the discussion, get the larger community on it. But Charles, so you get the last word out.
I'll be very brief, just to say, if there's one thing we learned, this funding model, so Chapter 7, a subsidiary body of the UN, assessed contribution, voluntary, donations-based. If there's one thing we learned from Sierra Leone, is that that's a terrible idea. Interestingly, the Secretary General said it, he called it early on, he said this is a terrible system to have. In addition to non-hiring staff, I mean, we were told our salaries, I worked at the SCSL at some point, our salary, they didn't know whether they would be able to pay us. Now think about what that means for an organization. So what that meant was, so this is just the additional point to add to Beth's excellent point, was that you had staff who now look for the opportunities elsewhere. So as the tribunal was being told to wrap up, the most experienced people are taking, they're taking the first job because you gotta pay your bills, right? You gotta pay your bills. And you didn't know where they would come from your employer. So they lost a lot of good people. So in my team in the Rwanda tribunal, where we were doing judgment drafting, we had our most experienced legal officers leave. So you had new people being hired, and you had the hard bid, and the defendant has been waiting for over 12 months for a judgment. And somebody has to draft that. Judges are in court. They of course give directions. It's kind of like the law clerk system. But my point is, there's a bad side to it that ties into the completion issue. So in the end, it's our political will, basically.
All right, let's start out with questions.
Thank you. My name is Abigail. I am a proud former student of Linda.
And a good friend.
Yes, now it's come to that. I wanted to go back to the complementarity debate because following what is happening in the DRC with Germaine Katanga, to me it's a form of reverse complementarity, and I would like to hear what the panel has to say about that. I'm curious where this is going with the ICC.
You might explain what the DRC is intending to do, that he's been convicted at the ICC.
He's been convicted at the ICC. He was sent back to DRC to complete his sentence, and now the officials in DRC are saying that they're going to charge him with new crimes, which I'm not very sure if they were covered within the ICC case in itself, but they're kind of related, and I'm wondering where we're moving with that, since there are issues of double jeopardy.
Of course, the DRC is claiming they were not covered by the ICC.
And Katanga has now served his sentence, correct?
Well,
Isn't he
certainly.
served? I thought he was released.
Not
Was
yet.
that-
He was just supposed to complete his sentence.
This is an anticipation.
Just to add on this Katanga, I mean, the other issue is the due process rights of Katanga, which, you know, is celebrated as a great conviction for the ICC. But in fact, of course, the scope of the charges were changed midstream. There was a 180-page dissent by one of the judges. So, I mean, it just brings up these issues of, and this sort of plays on the same point, but on the hybrid consensus courts, I mean, I think one of the tough questions is when you're creating new courts from scratch over and over again, you know, how do you create institutions and procedures that are fair? And that's my worry, I think, and along with funding and other stuff around victims. But
John, Chris.
Well, I don't know, does anybody have any response to that?
But, Leah, you want to go first?
I'm just going to, I think on double jeopardy, it's almost a cultural linguistic problem for me. I mean, what is a fact, right? And what is an act, right? And how does that fit into a double jeopardy notion? I mean, that happens between the US and European countries as
Well,
well.
the federal system and the
And the
state
federal and
system
state system.
have intergenerational.
And especially when you transcend deeper cultural borders and linguistic borders, who knows what the hell it is? You know, what is double jeopardy? And it gets also back to the political definition of things, right? It's what y'all want it to be. Or it's what the powers want it to be, if we talk about power. And I think that's a serious problem that involves almost everything that we've been discussing.
That may, as you say, may happen everywhere. I mean, the situation in which you have a plurality of jurisdiction dealing with the situation, it may happen that same facts, same acts, same conducts, same crimes, you can, I mean, have many angles from which they take the case, may be taken up by different jurisdictions. We have a case ourselves in the ICTY. There is a case now which is prosecuted in Bosnia, and the accused that has been acquitted for crimes in the ICTY alleges that this was covered by his acquittal, and so this is in violation of the principle of double jeopardy. This is a case of double jeopardy. So the ICTY apparently, I haven't read it in these days, received a request by the court there on the initiative of the defense to characterize the crime and see whether it was covered or not, and refused to do it. That went to the Residual Mechanism, of course, who did not adjudicate the case, of course, it's another court again. So, but they said we are not competent to deal with that question. So the question is with the domestic individuals, because the case is finished here, is not under our jurisdiction, it was under the jurisdiction of the ICTY, so there is nobody competent to decide this. Because all the questions after 2013 go to the residual mechanism. So the tribunal will not be, that adjudicated the case, will not be competent to characterize it again, because it cannot take a review case, cannot take again an old case under the law, under the system, which is clearly creates problem. So it will be for the domestic courts at the end to make the decision, and I don't know which will be the criteria they will consider. Will they apply the system of the ICTY to decide when two crimes are independent, which is what will be the system of the Supreme Court of the United States, essentially.
Yeah, Blockburger.
The Blockburger test. So essentially it's that test that has been adopted, or we'll use another test that is under Bosnian law the correct test. I do not know, but maybe use the domestic test. So there may be an overlap. There may be an overlap.
You know, I think I agree with that, because I think there's going to be very little that can be done, because it does get down back to the same content. It's interesting, though, that the ICTY had that rules of the road process. Fascinating. We were involved with it during the early days of the AAC. And that's part of what was happening, attempt to, when a case was being transferred down former Yugoslavia, there was kind of an agreement as to exactly what was going to happen with that case, and whether or not, in fact, there would be approval to pursue that case. But that doesn't exist with the ICC, so I think that's going to be somewhat problematic, and raises the larger issue. Ron was talking about this earlier, about what happens with the domestic jurisdiction. It's not shielding an individual, but actually doing just the opposite. Is using the system, violating kind of basic standards of fairness and impartiality, and using it for their own political means. And again, you can see the issue what's happening in a number of cases now, but what role does the court, what can the court do on that? And so far, they're not doing much. So it's an issue.
Well, I'll just say something really quick because Beth forced me to write an article on double jeopardy. Aren't you glad you did? I am very glad, and actually it was Fausto who convinced me that was the topic to go after on that issue at a symposium at Santa Clara. But so in most of the world, double jeopardy is called nullum crimen sine lege, no crime without law, nulla pena sine lege, no punishment without law. But I looked very closely at, because I knew the US system well from teaching it, and I looked at various systems around the world, and then I looked at how the ICC was set up. And it is interesting because it's asymmetrical in the ICC system. So that, again, it's like tipping the hat to complementarity, which will give the DRC a greater leeway because they can prosecute as long as it's not the same crime. Whereas if the DRC had prosecuted first, the ICC could not prosecute if it were the same conduct. I'll let you think about that. Jenny, go ahead, please.
I had a different question for the panelists, but I was wondering what you all thought about the idea, and the ICC statute provides for that, for the ICC to have proceedings in situ. So, and that has been considered, but it's sort of another midpoint, between domestic and international, where at least the court is moving to the place where the crime occurred, and there is maybe some legitimacy that way, and at least opportunity for victims, victims' families to attend, and for the national population, to see the proceedings happening. And you all may recall that judges here were riding the circuit in the early days, and that was an important way to get legitimacy and to unify the judiciary. So is that something that the court should be exploring more?
I would say definitely. As you know, the question has come up in the context of the Kenyan cases. I think the benefits are just tremendous, too tremendous in terms of the soft aspects of the development of the regime. When you have a centralized global system of any kind and you put it in the Hague, you're going to have to reach out, and it's not going to be Africa only, right? Right now it's Africa, it could be Eastern Europe at some point, it could be Latin America, or it could be all of these regions, and you've got to be able to reach out to those communities. And one of my most sort of striking moments in my entire foray, limited time I was spending in the tribunals, was the difference between coming out of Freetown, having worked at the Special Court for Sierra Leone, which is on the ground. That was one of the key advantages of it, sitting in the country, and how people were lined up at 6 a.m. in the morning for the opening of the Taylor case. The staff of the tribunal could not go into the public gallery. It was just so full. We were told to give up our offices at some point because the overflow was the cafeteria. And after the cafeteria, you had a monitor in your office. So they had like strangers like sitting in your office. Basically. But really, I'm just saying the tremendous interest in the defendant's case. This is just an arraignment happening at 2 p.m. They're on 6 a.m. in the morning, lining up. So in other words, great level of engagement only by a function of the tribunal sitting on the ground. Now I got a job at the Rwanda tribunal. I arrived in the Rwanda tribunal, and there was the closing of the Bagasora case, the alleged architect of the genocide. Public gallery, pretty much empty. Would that happen if that tribunal was sitting in Rwanda? Probably not, right? So I'm just saying that I think the models out there tell us enough to see that maybe there's good reason to bring it to the ground. The judges were divided. Actually, they were divided almost on regional lines there. The African judges supported bringing the tribunal to Arusha, not in Kenya, but just as sort of halfway the facilities are there. And you know what happened with that. There's a big division as a blow-up. I don't know whether they'll go back to it, but I think it will be good to go back to it.
And I've said that The Hague is not a parasite for everyone, because we now have the discussion about the Kosovo War Crimes Court being established in The Hague. So there you have the reverse, looking at The Hague as being, for political reasons, security reasons, that it was better to create this court and establish it in The Hague. So that's going to be interesting to follow, to see if that is taken up. I think it will.
I would not exclude on your question. I would not exclude any possibility which should be tested in practice. In general terms, however, I do not think that it would be a good trend to have the court going and having trials everywhere. Because, and that's not only for practical reasons. For practical reasons it's impossible because the court is too small to do that. So if a bench goes in a country for 1 year, 2 years, to hear a case, the court will not be able to work in the case. So there is some problem, in practical. But it could be a result of extending the size of the court to a certain limit. But there is another problem which intrigues me. When you have a situation where a huge number of crimes are committed, it would be fair to the accused, to the alleged responsible, to treat them with as much equality as possible. And the national jurisdiction is normally based on the place of the crime, nationality of the accused, nationality of the victims. These are the three criteria that you find in customary law in a way, because that follows almost by everyone. And universal jurisdiction is a derogation from that, but is attenuated by the obligation to give it to the state that matches one of these criteria, if possible, if the state accepts. The complementarity again recognizes this principle, because in principle should be those states who exercise the jurisdiction. Now, if you select 10 people, 20 people, bring them elsewhere or bring them to a different system of procedure and of adjudication, and the others are adjudicated differently by the country, by the national country, you immediately create a disparity. And we already experienced that in the Hague. People wanting to remain in the Hague, opposing the referral back, because the treatment in the Hague is better. The penitentiary regime is better. If you have to wait for trial at the Hague, it's not being in prisons in Bosnia. So, is that fair? I understand in certain cases it may be necessary to do without that system, but as strictly as possible, should be limited to the maximum possible. And if possible, the jurisdiction, and I join Mark on that, should be given to the states concerned, if possible. So bringing in the state a completely different system of justice, I don't know if it is a good idea. I would have some hesitation to push in that direction. But for this reason, essentially, for the fairness of the education.
So I'm Stephen Cody. I was not Linda's student, but she's been a mentor to me, so I really appreciate getting the opportunity
And
to
Stephen's
be here.
been a mentor to me too, because he's just done this amazing project. He's at the Berkeley Human Rights Center, and an amazing project interviewing victims in various situational countries. Go ahead, I should let you.
Well, thanks. No, that's actually the perfect leading, because I was going to ask about victims.
Well done.
It's as if we wrote a script. So, I mean, this is the question, which is, various tribunals have handled victims' rights and victims' participation in different ways, with the ICC giving them very extensive rights, and other tribunals, ICTY, limiting their roles significantly. And so, as these new hybrid tribunals are considered and developed, what is the role of victims in the view of the panel?
I'll just say one of my main concerns has been, I was definitely, and still am, a proponent for victims having a central role. It's a lot harder when you're dealing with mass crimes, right? Because the numbers of individuals who could constitute themselves as civil parties or as sort of official victims is huge. And why we were not able to anticipate that in advance and to create systems to address it, because what has concerned me most at both the atrocity in Cambodia and in the ICC is the sort of broken expectations where, you know, so much of the rhetoric around these institutions was that victims would have a central place finally, they were going to be brought in, they were going to have equal procedural rights, and I think when people hear that, they believe it. And so they actually thought that they would have those rights, and the rules in both of those institutions have really been changed midstream. And I think this is probably what your work has been so valuable for, is to kind of bring that disappointment to the fore, where we thought we were going to have this role, and instead it's been this role. And why we didn't have the foresight to say, okay, how are we going to make this real when we're talking about 1.5 million victims in Cambodia? And come up with some sort of a class action model, which is ultimately where they landed. And I don't think it's necessarily a bad solution, but it was so painful along the way, and it led to such infighting amongst counsel as they sort of scrambled to see who was going to be the representative who got to sort of stand up in court and this and that. I just think it was really unseemly the way it was handled. That's just one thought.
You know, I tend to go with Beth on this, and my experience in acting for a year at the Noon Che case in Cambodia and being there in the court and advising, so I was able to and I came there without any sense of whether I thought victim participation through the trial process was good or bad. As you've heard me, I'm all about accountability for the victims. But I walked away from that experience unimpressed. I thought it was I thought the victims' participation, when I say victims, it was in essence two lawyers. It wasn't as if you don't get a sense that all the victims were there. That's not it. And granted, I was on the defense side, but everything it was as if it was a double-barrel shotgun from the prosecutor and the victims' representatives. There was no light between that, and so the process permitted the victims' representatives to come out to participate in all aspects of the trial, and I just didn't have a good feeling about it actually. So I'm still a bit agnostic about it, I guess, but I just wanted to say from being there and watching it and experiencing it, I had some real problems with it.
Okay, you get the last word before lunch. Not that I want to pressure you to go.
Thank you, John. No, I mean, just the victims, just because you asked the question about the future, and one of the things I find fascinating about the Malabo protocol is that, in a sense, this interplay between taking the regional approach and an international approach. So I've suggested that some of the crimes that you see in the jurisdiction of the tribunal are driven clearly by regional concerns, about more or less about 10 of them. And the other are just driven by the national concerns in terms of reason, what have you. But when it goes to some of the mechanisms of the tribunal as well, so they do things like reproduce the rights of victims to compensation. So if you go to Article 45, compensation and reparations of victims, and I was like, whoa, whoa, whoa. After having the ICC's experience, and this goes towards Beth's point, probably that would have been one of those provisions that I would tweak right away from the statutory level, even if we wanted to keep to the principle. And obviously, it was animated by the notion that we don't want to do less than what the Rome Statute is doing for victims, which I don't know how much African states really debated at that point, because of course you would take different orientations in terms of that attitude. To some extent, reproducing a little bit of debate at Rome. That's what I expected. But they managed to put it in there. So it offers compensation, restitution, rehabilitation to victims. And in an African system where we know the struggle for resources are not going to be light, I don't know how they're going to make that happen. So in a sense, it goes towards that. In principle, maybe we'll see this coming up everywhere. We need to have new designs like this. But the difficulty is how do you make it?
But and what Beth was saying, it kind of raises expectations.
So much.
The ICC generally, I don't think has been that successful. The Cambodia tribunal has been successful all on that side. And so there's this sense that victims will be compensated, but in essence, it's not happening. So that's it's an uneasy feeling to
I would rather almost not keep it in the statute, make false expectations, like sell the tribunal. Oh yeah, this tribunal is going to give you the confidence. They're not going to have the resources like we don't have right now.
Putting it in, having it in there, taking it out, it's a whole other
Exactly. That's why I would have done it differently.
there is a I tend to agree with you, but there is it's been handled in a way that what counts is participation more than reparation. It's true there is the fund, but it doesn't go really in that direction. One could perhaps take the opposite view, that one should go for reparation, and this will be a trend in the UN, because look at the position taken by the crimes conferences. As of '85, there are resolutions of the General Assembly adopted that states under the obligation to repair the victims, to give reparation to this small crime in general. Of course, that was not imagined for mass crimes, but could be extended, the idea. Then if states are not able to do it individually, could be a community, could be given funds, but it should be done in that framework probably. And the participation, of course, is a bit, I don't know, a misunderstanding saying that the ICC gives participation and the ICTY did not. I mean, out of the, I don't know how many thousands of witnesses that were heard in the ICTY, at least 60%, 70% are victims. So they were heard, participation existed. There is no mechanism of participation, but in fact, most of the cases were adjudicated with the victims being in court and giving their stories, giving their view of their report of what happened actually. So there is some participation, but the reparation, of course, was not taken.
So we're going to break for lunch now, and in addition to our nutrition and nourishment, we're going to get intellectual stimulation in a conversation between Linda and Sarah Kanbar, who's the law review editor, who is supervising the symposium and the preparation of the material for publication.
We won't start that until 1:15 or
Okay.
so actually, I think everybody needs a chance to take a break and speak with all these fabulous people who have been here talking and sharing their ideas. So I'm probably preempting John and Omar, but please join me in thanking